Good afternoon to all of you who are tuning in from the East Coast and to all of you elsewhere with us. Good day to you. I'm back here in New York City. Last time I was with you, I was in beautiful Cooperstown, New York. And it's a little bit overcast here, but you certainly feel like summer's around the corner. Yesterday, it was in the 80s here in New York. We have a really interesting and varied program for you today, which if Kathy, you can go to the next slide, I'll walk folks through. We have a Buffalo office dominant program today. It is great to always be able to demonstrate to all of you that not only do we have a variety of areas of understanding as a firm, we also have offices across the state and in a variety of other geographies that are doing good work. And so you will hear from several attorneys from Buffalo, Suba as well from Syracuse, and here I am in New York City. But let me walk through more formally. So after I conclude opening the webinar, I'll turn over to Suba, who is back with us. Suba, of course, is in Syracuse and a regular on the webinar. He'll be looking at U.S. Department of Labor activity around overtime and the final overtime rule. Lots of interesting implications there that Suba will begin to unpack. Bradley Hoppy is with us from Buffalo, and Brad is looking at the FTC and its activity around non-compete clauses. Lots of layered implications to what's going on out of that agency. So more to come. After Brad, we'll hear from Arthi Jandan, and Arthi is, as I noted, in Buffalo, and she will be addressing gender-based restrictions concerning scholarships and student aid in the higher ed context. There's some activity there that we thought would be worth unpacking for all of you. And after that, Victoria, also in Buffalo, will be addressing an interesting crossover matter, CIRCIA, which is the Cyber Incident Reporting for Critical Infrastructure Act of 2022. Actually, Victoria and I are working on publishing a piece, which should be out shortly this week. And we're going to, by way of Victoria's comments, give you some updating on what's going on in this space around reporting cyber incursions, incidents, as you will, and some federal activity that's intended to kind of bolster that, but yet has lots of interesting wrinkles that all of you should be, as best possible, tracking, and it'll be our goal to make that the reality today. So with that, let me turn to our first of several speakers, who is Suba. And Suba Viswanathan is a member in our Syracuse office who is often on the program to discuss labor and employment issues consistent with the breadth of his practice. And Suba is in particular tracking closely what the U.S. Department of Labor is doing vis-a-vis overtime ruling activity, and there is a lot that we recognize will impact the various businesses represented here on the webinar that we want to make sure you're queued up for and keyed into. So with that, Suba, I want to turn it over to you. Thank you for taking this time to educate the audience.
Thanks, Gabe. So this is something that all of us in the labor and employment realm have been anticipating for a while. The USDOL issued its proposed rule back in August of last year. So we've all been, the comments have been rolling into the US Department of Labor, and we all kind of figured that, springtime or early summer would be the time that they would issue their final rule, and they just did. So next slide, please, Kathy. So for the executive, administrative, and professional exemptions, the current minimum weekly salary under federal law to qualify for those exemptions is $684 per week. The proposed rule increased it up to $1,059, which was the 35th percentile of the lowest wage census region in the U.S. The final rule is a little bit different from the proposed rule in that it increases the exempt salary threshold in 2 stages. So on July 1st, 2024, the minimum salary is going to increase to $844 per week. And on January 1st of 2025, it'll increase to $1,128 per week. The salary levels have to be exclusive of board, lodging, or other facilities. So if you include, for instance, a meal allowance or a lodging allowance or a car allowance or anything like that as part of your minimum salary, that has to be excluded when you compute it under federal law. There's no changes to the duties requirements. So for the executive exemption, people still have to supervise at least 2 or more full-time employees. They have to be responsible for managing, either the enterprise or a recognized subdivision within the enterprise. And they have to have authority to hire, fire, and make other sorts of personnel decisions, or at least make meaningful recommendations regarding those personnel decisions. For the administrative exemption, again, the duties have not changed. So it still has to be office or non-manual work. It still has to be related to the general business operations of the employer. And the individual must exercise discretion and independent judgment with respect to matters of significance to qualify for the administrative exemption. And for the professional exemption, there are still educational requirements that have to be met. That has not changed. There are still exceptions from both the salary level and salary basis requirements for certain positions. So teachers don't have to meet a salary level or a salary basis requirement. Lawyers, doctors, medical interns, and medical residents also don't have to meet a salary level or salary basis requirement. And again, that has not changed. That's not a new development. That was in the old regs, and it still is in the new regs. Next slide, please, Kathy. The minimum annual salary to qualify for the highly compensated employee exemption is also going to increase in 2 stages. So the current minimum annual salary is $107,432 per year. On July 1st, that's going to go up to $132,964 per year. And on January 1st, it's going to go up to $151,164 per year. Again, there's no changes to the duties requirements to qualify for the highly compensated employee exemption. Essentially, to qualify, an individual must satisfy at least one element of the duties test for the executive, administrative, or professional exemption and meet the salary test. So for instance, if it's an executive that's responsible for managing a subdivision of the enterprise, but they only have one person reporting to them, so they wouldn't otherwise qualify for the executive exemption, but they're paid this minimum annual salary, they could still qualify for the highly compensated employee exemption. Next slide, please, Kathy. The final rule also includes automatic increases every 3 years, beginning on July 1st, 2027. So effective on that date, the minimum weekly salary for the executive, administrative, and professional exemptions will be based on the 35th percentile of weekly earnings of full-time salaried workers in the lowest wage census region. And the minimum annual salary for the highly compensated employee exemption will be based on the 85th percentile of earnings of full-time salaried workers nationally. So there is a procedure by which the US Department of Labor will look at the data every 3 years and publish a notice regarding what the new weekly salary is for the executive, administrative, and professional exemptions, and what the minimum annual salary will be for the highly compensated employee exemption. And hopefully that occurs well in advance of the deadlines to comply. Next slide, please, Kathy. I think it's also important to talk about the minimum salary levels in New York and how those compare to the new federal salary levels. For the executive and administrative exemptions for 2024, the current minimum weekly salary to qualify for the executive and administrative exemptions is $1,200 per week in downstate New York It's essentially New York City, Nassau, Suffolk, and Westchester counties. And it's $1,124.20 per week in upstate New York, which is the rest of New York. So currently, those minimum salaries are both higher than what it's going to go up to on July 1st, 2024. So at least with respect to those exemptions, there isn't really any difference between what employers in New York are expected to do under New York or federal law. In 2025, effective January 1st, 2025, the minimum weekly salary in downstate in New York is going to go up to $1,237.50 per week for the executive and administrative exemptions. And it's going to go up to $1,161.65 in upstate. So again, those salaries are going to be higher than the minimum weekly salary effective January 1st, 2025 under federal law. However, employers have to keep in mind that there's no minimum salary to qualify for the professional exemption in New York. So the weekly salaries under federal law are the ones that are going to apply. So if you currently have professional employees who are earning the minimum federal salary of $684 per week, those professional employees will have to go up to the new minimum federal salary, or they'll have to be reclassified as non-exempt employees. One other difference under New York law that is important is that New York employers can count board, lodging, or other allowances and facilities toward the minimum weekly salary under state law. Still can't under federal law, but they can do it under state law. So to the extent that the minimum weekly salary is higher in New York State, if there are meals, lodging, car allowances, other sorts of allowances that are provided to those exempt employees that can bridge the gap between the federal salary and the New York salary, those can be counted under New York law. That's it for me, Gabe.
Sorry about that, and thank you. It was really helpful to hear from you, Suba. If you have a minute, there are several questions that have come through on the chat concerning nuances that I think are relevant to individuals who heard what you had to say. And the volume of questions suggests that indeed this is something people are paying close attention to. So we appreciate you taking the time to share your understandings and those ideas and elements that folks should really have in their heads as we move deeper into 24. So let me now shift to our next speaker, who's Brad Hoppy. And Brad is a member, as I mentioned, in Buffalo, as is the location for the remainder of our speakers today. And Brad has been tracking the FTC's activities around non-compete clauses for some time and is here to provide an update. It is obviously really significant for those of you in various businesses that could be touched by this activity. We wanted to make sure you had the latest. Brad, we thank you for coming on to the program. Welcome back.
Thanks, Gabe. Good afternoon, everyone. This one is a long time coming. And unfortunately, what the FTC has just approved is likely to have very significant impacts on businesses throughout the United States, if and when it goes into effect. But before we talk about that, I think it makes sense to at least spend a minute or two here kind of going over how we got here, the origins of this FTC final rule. Kathy, next slide, please. And the origins go all the way back to July 2021. On the 9th of July 2021, President Biden issued an executive order on the use of non-compete agreements. Non-compete was just one part of it. It was just more generally relating to unfair business practices. That executive order, though, did not use the type of language that you would expect if what would ultimately come out of that executive order was some sort of ban on non-competes. Instead, the executive order encouraged the Federal Trade Commission to curtail the unfair use of non-competes and related covenants. As you can see, there's not the word ban in there. There's not a prohibition. curtail and encourage certainly is inconsistent with that. Based on the language in the executive order, most practitioners, me included, did not expect that what would ultimately come from this order would be any kind of broad ban on non-competes, but instead would be limited to maybe low-income workers. Next slide, please. It came as some surprise then in January 2023 when the FTC released its initial proposed rule on non-competes. That proposed rule did not seek to simply curtail the unfair use of non-competes. Rather, it sought to ban all non-competes for the term workers, which is broadly defined under that proposed rule, with very limited exceptions. Like every proposed regulation, there was a mandatory comment period. That's normally for a period of 90 days. In this instance, it was much longer than that. It was extended a few times. And during that mandatory comment period, there were 26,000 comments from the public, both individuals and small businesses that were impacted by the proposed rule banning non-competes. And as it turns out, the vast majority of the comments supported the proposed rule and the proposed ban. Next slide, please. All right, so fast forward to April 23rd. Last week, the FTC voted on a 3-2 vote to approve its final rule banning non-competes. Now, the final rule declares that the vast majority of non-competes against workers an unfair method of competition. In addition to seeking to effectively ban non-competes, it also seeks to prohibit the use of de facto non-competes. And by that, I mean provisions in an agreement that have the effect of prohibiting competition. Some examples of that could include very broad non-disclosure provisions, could also include financial penalty provisions, and it could include broad non-solicitation and non-interference provisions. I mean, these are provisions that a lot of employers utilize with key employees, and certainly based on what we see in this final rule, that they could be on the chopping block. So we certainly encourage clients to take a hard look at their provisions to make sure that they do not constitute de facto non-competes. Now, the effective date of this rule is 120 days from publication in the Federal Register. That has not happened yet. The expectation is that that publication date will be some point in the very near future. So I think it's probably safe to assume at this point that the effective date of this non-compete ban will be at some point in September of 2024. Next slide, please. There are some exceptions to the non-compete ban, and I have them listed right here in this slide. The first one, you could still use a non-compete provision during the term of employment. What the ban seeks to prevent is a non-compete on a going forward basis after the employment ends. The second exception is for a senior executive. And the exception is, for an agreement with that narrow class of senior executives, it's going to be someone who has policy-making authority on behalf of the company and makes a salary that's in excess of, it's a number around $151,000. All right, but this exception is limited to non-competes that are in effect as of that effective date, that 120 days after the rule is published in the Federal Register. Note that this exception does not apply to new agreements that are entered into after that effective date. So this is a very narrow exception. The third exception is a non-compete that's entered into ancillary to the sale of a business. This is something that's always been considered a little different than your normal employment-related non-compete, and this rule recognizes that. And finally, the last exception is that it does not apply to pending litigation. So if you have pending litigation to enforce a non-compete, you can still proceed with that litigation. The other exception is where there's future litigation relating to a cause of action for breach of a non-compete that has already accrued. And by accrual, that means, where there's already been a breach of the non-compete prior to the effective date. So these are your limited exceptions to the non-compete ban. I think it's also important to note, and this is not in the slides, and I apologize for that, that there is limited jurisdiction of the FTC. And because of that limited jurisdiction, not all industries are going to be subject to this ban. For example, the FTC Act expressly excludes banks, savings and loan institutions, federal credit unions, common carriers, and foreign air carriers from its purview. So these industries are not going to have to comply with this ban, and non-competes can continue for those specific industries. Similarly, the FTC Act does not apply to true not-for-profit entities. Now, that's a very fact-specific inquiry to determine whether or not a company is a true not-for-profit. But if you do meet that standard, then you too will be exempt from this non-compete ban and can continue to utilize reasonable non-competes. Next slide, please. All right, so assuming you are subject to this non-compete ban, as an employer, what do you have to do? Well, the rule provides that an employer must notify all workers subject to the rule that the non-compete will not be enforced against that worker. Now, the term worker is broadly defined under the rule, and it includes not only employees, but also independent contractors, interns, volunteers, apprentices, pretty much anyone that provides some sort of service to the company. Not only that, but the definition of worker extends not only to your current employees, but also your former employees as well, who are subject to non-competes. So obviously, depending on the size of your organization, it can be a very onerous task to provide notice to every single employee, both current and former, that is right now subject to a non-compete restriction. One thing that does help is that the final rule does include model language that satisfies the requirement, and we certainly encourage clients to use that model language. The rule further provides that this notice must be delivered to all current and former employees subject to non-competes by mail, email, or text message. And again, that must be done within 120 days of the final rule being published to the Federal Register. Next slide, please, Kathy. All right, so what should employers be doing now to prepare for this rule? Well, I think number one is don't panic. You need to wait and see what happens with respect to this non-compete ban. There will be several legal challenges to the final rule, and it's going to be on numerous grounds. In fact, we've already seen a few complaints being filed in federal district court in Texas. There's one in the Western District, there's one in the Eastern District, challenging this final rule on several legal grounds, many of which we believe to be meritorious. So, because of those pending actions and what we believe will be further challenges, right now a wait and see approach is what we recommend. That doesn't mean you just sit back and do nothing. You do need to prepare as if this non-compete ban will go into effect by that effective date. So we recommend that you begin identifying workers who are subject to the non-compete ban sooner rather than later. Again, this is both existing employees and former employees. You want to make sure that if and when that effective date comes, you are in the best position possible to provide the required notice under the terms of that rule. In addition, you need to start reviewing your agreements now for those de facto non-competes. Make sure your non-solicitation provisions, your non-disclosure provisions are no broader than necessary to protect the legitimate interests. Make sure they're not going to be considered a de facto non-compete that has the effect of prohibiting competition when that employee leaves. Now, like I said, this is in flux right now. We have a final rule that's been approved. It's going to be published soon, but we're going to keep a close eye on these legal challenges. And certainly, if there's anything to report on that front, we'll be there and we'll provide whatever guidance is necessary. Thank you.
Brad, terrific, really helpful. Thank you. One question for you before we shift to our next speaker. You mentioned in describing some of the types of organizations that are exempt from this, that a true not-for-profit organization would be among that cohort. I'm wondering, is true that term of art defined within the final rule, or is that really, as you indicated, a fact and circumstances kind of approach that each not-for-profit is going to have to take?
Well, thanks, Gabe. That's a very good question. The rule itself doesn't mention and doesn't distinguish between for-profit and not-for-profit corporations. This is something straight from the FTC Act and the limited jurisdiction of the FTC as provided for in that act. there's a body of case law, out there that kind of defines the criteria for a true not-for-profit. So, it's going to be very fact specific. There's a number of different, elements that a court's going to look at to make that determination. So unfortunately, it's just something that's going to have to be looked at on a case-by-case basis, for each client, for each company, to determine whether or not they're within the scope of the act.
That's really helpful. Thank you. I know that we have plenty of not-for-profits tuning in as just one of our reliable cohorts within our audience. So I thought to ask, and I thank you for that response. And if any of you, whether organized as a for-profit or not-for-profit, have questions about the FTC activity, of course, Brad and other attorneys at the firm are here to help. So again, Brad, thank you. Let me shift to our third speaker for the afternoon, besides me, and that's going to be Arthi Chandan, who's also with us from Buffalo, around the corner in the office, to talk about a discrete set of issues. These deal with higher education. And as I mentioned, Arthi is focused on gender-based restrictions, concerning scholarships and student aid. So Arthi, why should we be focused on this right now? What's changing in the environment that would lead this to be the right time to be talking about this?
Thanks, Gabe. So kind of what's been shifting is there's been an uptick in complaints to the Office of Civil Rights with the U.S. Department of Education. I'm sure you can think of a lot of colleges and universities when you're scrolling through scholarships or financial assistance. Some of them say, this is intended for women in STEM or women in a particular program. And there have been an uptick in complaints from students kind of saying that these scholarships are discriminatory and they exclude a whole group of individuals, namely male students. That happens to be the most common complaint. So we figured, it would be good to kind of let you all know what's going on and kind of what you should be looking out for and proactive steps that you can take, before, hopefully to prevent a complaint from coming in. So Kathy, if we could start the slide.
Thank you.
Title IX prohibits discrimination based on sex in education programs and activities that receive federal assistance. And this includes a ban on single-sex scholarships unless they meet certain narrow exceptions as to how they're administered and awarded. And as I mentioned, a lot of schools still do it. There are a lot of scholarships out there that, based on the desires of the donors or whoever it may be, but that actually is in violation of Title IX. One of these narrow exceptions is to overcome the effects of conditions which resulted in limited participation in its education program or activity by people of a particular sex. But it should be noted that this exception is only available to overcome actual discrimination in the school's own education program, not to overcome, the effects of societal conditions that have resulted in limited participation by people of a particular sex in education programs or activities generally. So you have to tailor it to the program in your own school that you have noticed there seems to be, discriminatory results between the individuals receiving the aid. And the aim with this is to ensure equal access to educational resources and opportunities for all genders and to promote an environment free of sex-based discrimination. Next slide, please. So over recent years, as I mentioned, the Department of Education Office for Civil Rights has opened hundreds of investigations into sex-specific scholarships and programming. As of today, on their website, there are 238 open investigations into single-sex scholarships at universities. I believe back in 2020, there were only about 35 open investigations. So you can see this is something that there's an uptick and it's happening fast. And as I mentioned, the investigations are generally focused on scholarships and programs that are available exclusively to women. So, for example, women in STEM or programs for limited to female students whose criteria grant preference to female students. So that tends to be the majority of the complaints that are coming in. Next slide, please. So there are a few things that a school can do to ensure compliance with Title IX. Generally, the best and only way to ensure compliance with Title IX is to administer and award scholarships and aid in a manner that makes each award available to individuals regardless of sex or gender. And a way to do this is known as the pool and match method, noted by the Office of Civil Rights. So just a brief description of the pool and match method. So it's created by legal instruments such as a will or other gift, where students apply to a unified pool of financial assistance, and then the school assigns sex restricted awards to the applicants as necessary to satisfy Title IX. But it should be noted that a pool and match or similar system may not be used unless the financial aid is created by a will, a trust, a bequest, or some other similar legal instrument, or by acts of a foreign government, which require that the awards be made to members of a particular sex. Next slide, please. So one thing to keep in mind when you're kind of looking at your scholarships is to really pay attention to the descriptions of the scholarships, whether that be on your website and a catalog, anything like that. The title or description of a scholarship, fellowship, or any other form of financial assistance can be reasonably perceived as, if it can be reasonably perceived as sex restricted, Title IX may be implicated. So where the title of a scholarship raises an inference that the school or university imposes a preference or restriction based on sex, the Office of Civil Rights has required that schools clearly state in their public-facing communications, as I mentioned, whether it's website, catalogs, materials, anything public-facing, they require that the scholarship that the description states that it's being offered without a preference or restriction based on sex. So in some instances, it's important that you go back and you revise those descriptions so that it's clear that they're being offered without a preference or restriction based on sex. Next slide, please. So if you receive a complaint or if you don't receive a complaint, be proactive, because ensuring that scholarships and other financial assistance are compliant with Title IX takes time. So in the event that you haven't received a complaint, take a look at your scholarships now and identify any potential issues you might have. And if you have received a complaint, don't hesitate to reach out to us. Oftentimes revising current scholarship criteria or kind of creating that pool and match system that I mentioned previously, it takes time. You have to plan and communicate with donors. So even if you're not sure, but you think that some of your scholarships might violate Title IX, reach out, have us take a look. The earlier the process is started, the easier it is for us to revise the scholarship. And also, if we can proactively communicate with individuals in the Office of Civil Rights and let them know that we're working on it, we might be able to prevent an investigation from ever being opened in the first place. So I think they are very receptive to knowing that proactive steps are being taken to kind of revise these scholarships and create different ways to ensure compliance with Title IX. Next slide. Sorry. So just if you have any questions, you can reach out to me. You can reach out to Seth Gilbertson or anyone at Bonds, in our higher education practice group, and we're happy to help.
Arthi, thank you so much. To your point about thinking ahead and working upstream, absolutely, bond attorneys are here to be supportive, and it may not be something that every institution of higher education tuning in has been thinking about, but with any luck, we have raised it as an issue that now you can look into Let me now turn to the final speaker for the afternoon. For those of you who don't yet know Victoria Okrzycki, Victoria is with us from our Buffalo office as well. I have had the pleasure of working with Victoria on a variety of issues that overlay us between health and cybersecurity and data privacy. And CIRCIA is really in that space. I've written previously about CIRCIA, which, to be clear, does not necessarily only affect healthcare, but the implications for healthcare are pretty profound. And so Victoria is going to be talking about what's going on with CIRCIA. It's a rulemaking process that's on its way. We're not at the final stop on that rulemaking progression, but there have been some really important updates by way of what CISA has put out through an NPRN that Victoria is going to be summarizing. So Victoria, thank you for coming back onto the program and welcome.
Thanks, Gabe. So as Gabe mentioned earlier this month, CISA, the Cybersecurity and Infrastructure Security Agency, recently published its notice of proposed rulemaking in the Federal Register. And basically it's implementing reporting requirements for covered entities and based on covered incidents. And notably, this is probably going to cover a lot of industries, mostly, CISA actually noted it believes that over 300,000 entities will be subject to this rule. Next slide, please, Kathy. So CIRCIA was enacted in March 2022 and required covered entities to report on covered cybersecurity incidents to CISA and actually tasked CISA with developing and implementing regulations surrounding the reporting requirements. And on April 4th, CISA published its long-awaited proposed rules in the Federal Register outlining cybersecurity reporting requirements for covered entities. And currently, the public commenting period is still open until June 3rd, 2024. And under CIRCIA, covered entities must report on cybersecurity incidents within 72 hours the incident was reasonably believed to have occurred. And covered entities must also report ransomware payments within 24 hours of the payment. Next slide, please. So CIRCIA defines covered entities as entities in a critical infrastructure sector as defined in the Presidential Policy Directive 21. And under that policy directive, there are 16 critical infrastructures outlined. However, CISA clarified that definition by requiring critical infrastructures to meet one of two criteria based on size or sector. So regarding size, the infrastructure must exceed the Small Business Administration's small business standard, which varies based on industry, annual revenue, and number of employees. And CISA did not intend for all small businesses to be exempt from this rule, which is why it decided to include the sector-based criteria. And that covers some industries such as the chemical facilities, communication services, manufacturers, financial services, and education facilities. And in total, in the proposed rule, there are 13 industries that fall under the sector-based criteria. Next slide, please. So under the proposed rule, these covered entities are only required to report substantial cyber incidents, which includes substantial loss of confidentiality, integrity, or availability of a covered entity's information system or network, serious impact on the safety and resilience of a covered entity's operational systems and processes, disruption of a covered entity's ability to engage in business or industrial operations, delivery goods or services, unauthorized access, to the covered entity's information system or network or any non-public information it contains. And the proposed rule also includes examples of incidents that are not substantial and therefore do not have to be reported, which includes any lawfully authorized activity of a government entity, state, local, tribal, or territorial government entity, when a cyber incident is executed in good faith in response to a request by the owner or operator of the information system, or the threat of disruption such as extortion. Next slide, please. So as I mentioned earlier, CIRCIA required covered entities to report covered cyber incidents within 72 hours. Ransomware payments must be reported within 24 hours of the payment. And CISA actually included a third requirement. So when a company is experiencing both a covered cyber incident and then a ransomware payment, they must report that to CISA within 72 hours of the cyber incident occurring. And CISA also included instances where covered entities must submit a supplemental report, and that must be done within 24 hours of the new information becoming available, or if a covered entity makes a ransomware payment after previously submitting a covered incident. Next slide, please. So there are also 3 exceptions to the reporting requirement. So a covered entity is required to submit a substantially similar information within a substantially similar time frame to another federal agency that has an information sharing agreement and mechanism with CISA. The covered entity or specific functions of those entities concern the domain name system, and a federal agency is required to report the incident to CISA pursuant to the Federal Information Security Modernization Act. And most of the focus has been on the first exception, mainly because there currently are no information sharing agreements with CISA and other federal agencies. And also, this is more applicable to covered healthcare institutions under HIPAA because they currently have to report a breach within 60 days to HHS, which that is in a substantially similar time frame comparing the 72 hours to 24-hour requirement that under the CISA proposed rule versus the HIPAA rule. So unfortunately, we have to wait until the rule is finalized to actually see how that will play out. Next slide, please. So some of the contents of the report must include, obviously, the entity's name, the type, the address, contact information, the description of the incident. So that would include the impacted systems, networks, devices, and also the locations and the technical specifications that were breached. Also, any known information about the perpetrator. Some hackers, attackers, whatever you want to call them, kind of have a signature. So you can report that to CISA as well. And also any mitigation and response tactics that the entity took. So hiring a forensic investigations team to find the root cause of the breach. Any other instances engaging law enforcement and the breach notification letters that have to go out, any credit monitoring services that a company will also offer. And CISA also includes requirements for the supplemental reports, which is the purpose of the supplemental report, which mainly would be any new information or the ransomware payment that was subsequently paid, and if applicable, whether the cyber incident has ended. Next slide, please. So there are 3 enforcement mechanisms that CISA can take if an entity fails to report a cyber incident. So first, they can issue a request for information. So if they do not report the incident within 72 hours or 24 hours, if it's a ransomware payment, CISA can issue a notice if it reasonably believes that an entity was subject to a breach. And in the proposed rule, CISA indicates that the request for information is not a final agency action and does not propose any legal liability on the company, and it will mainly be treated as the initial reporting of the incident. And if a company does not respond to the RFI or does not provide some adequate information, then the CISA director can issue a subpoena to compel the information about the breach. And lastly, the CISA director can also refer the non-compliance to the Attorney General for suspension, debarment, or acquisition penalties. And this action may be brought in any district where the covered entity resides, is found, or does business. And just moving forward, Bond will continue to monitor this proposed rule, and we will report when it's finalized. Up until then, as I mentioned, the public has the ability to comment on this proposed rule until June 3rd. And yeah, if you have any questions, always feel free to contact us.
Victoria, thank you so much. And it's important to note that CISA has not before undertaken rulemaking. It's a fairly new federal agency that branches off of the Department of Homeland Security itself, not a terribly old agency. So there's a lot of learning that the agency is undertaking. And to your point around the overlays with other longer existing structures such as HHS and healthcare oversight, it'll be really interesting to see how all of this ultimately interconnects. And until the rule is final, we'll be tracking the details and the changes. So again, thank you, Victoria, for coming on the program. Let me, of course, take any question that we haven't answered already, although it looks like in the chat, we've gotten to them. So if Kathy, you'd get to the next slide, please, I'll just remind the audience about the labor and employment and human resources conferences that Bond is hosting. We, of course, do this annually because we know how important it is to all of you. There'll be various gatherings across New York State. I'll personally be presenting at the one in Westchester as well as the one in New York City. And I look forward to seeing those of you who attend those in person. And I know many other bond attorneys will be doing the same across the state. Again, all an effort to make sure that you have the information that you need. I will be back with you in 2 weeks' time. In the interim, as we move into May, our next webinar will be hosted by Kristen Smith. And of course, very much looking forward to being with you as we get further into May, and wishing you all a terrific end to this month of April. In the meanwhile, be safe and we'll see you soon.